It has been too long. Lots of legal news, and Canberra has gone into lockdown, so welcome to the working from home desk and lighting situation. A big one that hit the press a few weeks back is the passing of the Surveillance Legislation Amendment Identify and Disrupt Bill of 2021, now an Act. SLADE is not well understood, and one clue that it's not well understood is how the criticisms in the media are vague and non-specific. Worse, some journalists give you a hint of what's in the law without telling you specifically what it means. For example, SLADE allows police to modify, delete, add, copy data. One commentator, a Mr. Jordan Shanks of Friendly Geordie's fame, claimed that the new laws meant that they, by which we think he means ASIO, could legally hack Friendly Geordie's accounts, pretend to be him, try to entrap others with it, and, here's the scariest part, doctor evidence. So what's going on? Is Australia now a police state? The legislation provides 3 new powers to the Australian Federal Police and the Australian Criminal Intelligence Commission. The first, data disruption, is a covert power to disrupt data to frustrate criminal activities online. What do we mean by disruption? Well, that means adding, copying, deleting, or altering data held in a computer. Now that bit sounds worrying. Why would police be permitted to add, copy, delete, or alter data? Is it really, as Mr. Shanks claims, to doctor evidence? No. Police already had this power in other contexts. Very famously, they had this power associated with search warrants, where the matter concerns information held on computers. When the AFP raided the ABC to look for documents that had been leaked, for example, the warrant authorised officers to add, copy, delete, or alter other data during the search. In that case, it was the existing Section 3F of the Commonwealth Crimes Act that applied. It's also in other legislation relating to police powers to access data held on computers, and not just police powers, but other intelligence agency powers as well. In other words, this provision is not new, this is not its first rodeo. So why would we need this power? Well, maybe you've got criminal activity taking place online where the likelihood of securing a prosecution is very, very low. It's a network where everybody is very careful to conceal their identity. But it has some weaknesses. Even though the police can't secure a conviction, they could disrupt the activity. Should the police be permitted to disrupt the criminal activity, or should police agencies throw up their hands and say, gosh, it looks like we just can't do anything? Some very, very sensible people say yes. And they have very rational reasons for saying so. Under this view of the world, police are only able to interfere with people going on about their business if it is for the purpose of investigating an offence that has been committed. Imagine a police officer formed the view that you were about to be, or likely to be, committing an offence by driving your car. And just in case we stroll into strawman territory, we'll be really clear. The offence that we're talking about here, that you're about to be or likely to be committing, meets the same standard as in this law. Not all crimes meet the threshold, but it's tedious to go through this in detail. As a bit of a broad brushstroke, the bill refers to a relevant offence, which was already defined in the Surveillance Devices Act to mean, again, in very, very broad strokes, offences that are punishable by a maximum term of imprisonment of 3 years or more, or for life. Importantly, and this is a bit that too many people simply gloss over, this is a Commonwealth law, so the relevant offences at state law are those which have a federal aspect. Now, what does that mean? Basically, it means where the AFP or the Australian Criminal Intelligence Commission are investigating the state crime. So that's the scenario. Police officer forms the view that you're going to use your car to commit a relevant offence. She runs off to an eligible judge or AAT member and says, look, I really want permission to slash these tyres. If I slash these tyres, I'll disrupt the offence. If the judge or AAT member agrees, they get the warrant to slash your tyres. I think that reasonable people can disagree about this one. When terrible crimes are committed, we often get the public saying, why didn't the government stop this terrible crime from being committed? So maybe the public is on the side of giving police more powers to prevent crimes. On the other hand, it feels a little bit pre-crimey, right? We give the police powers to interfere with you prior to you committing an offence. It's definitely not clear-cut, and there are a range of opinions. Maybe you'd be more comfortable with this if the threshold were higher, for example. Maybe you'd allow the cops to slash your tyres if it would be highly likely to save somebody else's life. You don't need to be absolutists about being yay or nay on this question. An example. Here is notorious criminal, the Mad Hatter. He is extremely good at using anonymizing technologies online to obscure his identity and the identities of his collaborators. The AFP forms the reasonable belief that he is using these technologies to orchestrate the importation of a commercial quantity of, like, the worst drug that you can imagine. The AFP doesn't have enough information to secure a conviction safely, nor does it have enough information to identify the other people in the plot. But it does know that if it messes with the settings on the Mad Hatter's computer, he won't be able to log into the network for a few days. Now, previously, there wasn't much the AFP could do. Now, the AFP can apply to an eligible judge or AAT member to disrupt the data on the Mad Hatter's computer in order to frustrate the plot. And that disruption power is broad for two related reasons. First, because you need a wide range of tools available to accommodate for the wide range of situations that can arise with regard to online criminal activity. Second, unlike some other countries, Australia is very keen on ensuring that spook powers have very clear heads of power in statute. So the language ends up being unnecessarily and unnaturally detailed and spookier. One final point that's worth making is the data disruption warrant is not available for collecting evidence. There's a different warrant regime for that. But in the process of disrupting the data on the Mad Hatter's computer, the AFP might find evidence of other criminal activities. That information is admissible if they decide to prosecute him for them. Again, you can have reasonable disagreement about whether that's appropriate. Second power, the network activity warrants. This is a separate power from the data disruption power. Here, police know that there is an online network of criminal activity, but unlike before, we don't know who is using the network. Again, we have the same relevant offence threshold as before. Think punishable crime by up to 3 years or more, and with a federal aspect. A bit differently, it has to be the chief officer of the agency to apply for the warrant. Data disruption warrants were available to officers. This one has to go through the top. Also, unlike the data disruption warrant, this one is for intelligence collection. It's a search warrant for when you don't know the identity of the person that you're searching. So, similar to a search warrant, the language of Section 3F of the Commonwealth Crimes Act is back. If police need to add, copy, delete or alter data in order to access a device, they can. Small potatoes. This power to add, copy, delete or alter data is also available for when police are concealing that they've undertaken a search. Again, this should not blow any minds. Now, some of you in the audience might already be experts in the Surveillance Devices Act, and you might be saying to yourself, Mark, how is this different from a computer access warrant that already exists in the Act? And I would say that is a very astute and informed question, and I am glad that you asked it. A computer access warrant allows police to access information that is stored on a target device. Law enforcement officers apply for the warrant to access the information on the target computer to collect evidence. Importantly, access to the data must be necessary for the purpose of collecting the evidence. A network access warrant, on the other hand, allows the chief officer of the AFP or the ACIC to access data in the computer that will substantially assist in the collection of intelligence that relates to the group who is accessing the network. In essence, there's a trade-off. Police can be less certain about the access being necessary, but you have to go to a higher level of the organisation with more scrutiny attached in order to obtain it. When you don't get clear information about why the existing powers aren't enough, it is more difficult for members of the public to scrutinise why additional powers are needed, or why the existing power cannot just be amended. It looks sneaky. Network access warrants really do look like a sequel. Computer access warrants 2, Electric Boogaloo. And now we get to the big kahuna, the account takeover warrant. The existing law is that police can negotiate with somebody to take over their account. Hello, Mr. Hatter, you are Nick Sunshine. Ooh, there he is. Hello, Mr. Hatter, you are Nick Sunshine. If you help us to identify other individuals of concern using your login details to the online criminal network, maybe we can come to an arrangement about charging you with a lesser crime. And Mr. Hatter consults his lawyer, and they come to an arrangement, and the cops roleplay as Mr. Hatter for a bit in order to hunt down Mr. Hatter's accomplices, the March Hare and Shub Niggurath, the black goat of the woods with 1,000 young. Account takeover warrants means that the police no longer require consent, but it comes with a lot of strings attached. Again, we're talking about relevant offences. Further, we're back at the level of necessity rather than very helpful. The warrant is only available from a magistrate. The 2 other warrants that we talked about earlier were available from eligible judges and appointed AAT members. The warrant authorises taking control of the target account to enable the collection of evidence. Again, police can add, copy, delete and alter data to access the account. The warrant does not authorise impersonation. There's no head of power for impersonation here, and while that is true, it is only part of the story. It is in theory possible for police to impersonate a person using different powers that they already have. An account takeover warrant used in tandem with, for example, Controlled Operations Authority could enable impersonation. If police agencies want to do that, it means that their activities are subject to the oversight mechanisms applicable to both powers. The account takeover warrant is overseen by a magistrate. The Controlled Operations Authority is overseen by the Ombudsman and Parliamentary Reporting. It's an interesting way of duplicating oversight of what is quite a draconian power. All of these powers have a sunset date, expiry date. This is called sunsetting. It's an interesting mechanism that says, look, just because you got this through Parliament once, you will lose this power unless a future Parliament, with potentially very different members and a different Senate crossbench, agrees to give them back. With the very, very high degree of bipartisanship between the Coalition and the ALP, largely as a result of negotiations through the Parliamentary Joint Committee on Intelligence and Security, you could argue that this is window dressing. Civil society definitely struggled with this legislation and talked a whole lot of nonsense about it. Here is the Digital Rights Watch asking for Slade to be referred to the Independent National Security Legislation Monitor for a review. They apparently hadn't read the Slade. Schedule 3A had already been amended to include a statutory requirement that the INSLM undertake a review of this legislation within 3 years. Let's go back to Mr. Shanks's very unusual claims. First, Attorney General's isn't a portfolio agency of the Department of Home Affairs. Second, although Mr. Shanks thinks that the Department of Home Affairs is a shadow government of Peter Dutton's design, it was actually the brainchild of the ALP while they were in opposition during the Howard years, and not Dutton. Kim Beazley had it as an election campaign promise in 2001, Mark Latham had a detailed org chart drawn up for the 2004 federal election, and Kevin Rudd had an even bigger agency in mind for the 2007 federal election. Upon becoming Prime Minister, Rudd was advised that this was not actually an idea that he wanted to pursue, and he abandoned the policy. Third, as should already be pretty clear already, his more specific claims about Slade are incorrect. So Mr. Shanks's producer, Christo Lanka, was charged with an offence under Section 13 of the Crimes, Domestic and Personal Violence Act of 2007, which is the New South Wales Act. This carries a maximum penalty of 5 years imprisonment. 5 is greater than 3, so it does meet one part of the test. But the offence here does not have a federal aspect, and so it fails. I can see some of you are ready to hit the comments and say, but what if Mr. Barilaro instructed the Fixated Persons Unit to refer the matter to the AFP just so it had a federal element? Well, there is a lot of conspiratorial unreality to this proposition that, to be completely honest, doesn't seem terribly healthy, but let's play along. First, the Fixated Persons Unit would have to form the view that the matter should be referred to the AFP, which would be very strange. Then, the AFP would have to look at it and not immediately respond with, "Are you sure you want to refer that to us? This seems kind of weird and should probably be referred to the New South Wales Law Enforcement Conduct Commission." But let's say that they don't do that because we just got a string of bad luck with dodgy cops. What protects the Mr. Shankses and Mr. Lankas? Well, let's say that the AFP inexplicably wanted to disrupt the data on Mr. Shanks or Mr. Lanka's computer to prevent some future stalking of Mr. Barilaro or something, which is weird. They'd need to get an eligible judge or AAT member to approve the warrant. Let's say that the AFP wanted a network access warrant. First, why would they need a network access warrant? Second, they'd need the Commissioner of Police to make the application to, again, a judge or AAT member. Neither the data disruption warrant nor the network access warrant seem relevant to Mr. Shanks's concerns, and yet those were the two warrants that involved the delete, copy, add, modify data aspects. Finally, we have, the account takeover warrant. I don't have a slide, I'm sorry. The AFP would need to convince a magistrate that taking over Mr. Shanks's account was somehow necessary for the collecting of evidence about the stalking, and that this was an appropriate use of the power. So that's a magistrate who needs to approve this. Good luck. Further, they couldn't impersonate him using this power, and instead they would need to use a power that is overseen by the Ombudsman. Again, good luck to them. In fairness, this is a difficult piece of legislation, and mainstream media companies erred on the side of conspiratorial fantasy rather than a close analysis of the legislation. At the same time, there were conceptual issues here that are worth debating properly and sensibly. As I've shown throughout this video and the earlier videos on Toller, you have to grapple with some big philosophical questions to work out how comfortable you are with some powers, and how comfortable you are with the way that the legislative process worked. But in order to have those discussions, you really need to be playing with a decent set of facts and not going of conspiratorial fantasy. So that is it for this one. Like and subscribe to help my metrics. Argue with me on Twitter at Legal Reckoning. And with luck, I'll have more legal explainers uploaded soon. Bye-bye.